Do you want to protect thousands and possibly millions of dollars from the cost of long-term care? I'm elder law attorney Banks Ladd of the Ladd Firm. This video will prepare you for your free long-term care telephone consultation with one of our attorneys. If you have not already done so, please call 251-431-6014 to schedule your free telephone consultation. The main goal of planning is to qualify long-term care patients to receive Medicaid, VA, or other government benefits to pay for nursing home or assisted living facility care. The problem is that most government benefit programs limit the value of certain types of assets that the patient and his or her spouse can own in order to qualify. Therefore, planning is necessary to protect or shelter assets for the benefit of the patient, the spouse, and their children when applying for benefits. We can help your family shelter thousands and possibly millions of dollars worth of assets. Planning is necessary because long-term care is very expensive. For example, the median cost of private nursing home room in the United States is $106,000 per year, which is not covered by Medicare. Therefore, nursing home bills can rapidly wipe out a family's life savings, leaving the patient and his or her spouse destitute unless the patient can qualify for Medicaid. Unfortunately, patients and their spouses can have very limited assets when applying for Medicaid. However, certain types of assets are considered exempt by Medicaid. By converting countable assets into exempt assets, Medicaid applicants can protect assets for the support of their spouses and leave an inheritance to their children. Fortunately, we have many strategies for sheltering assets when applying for Medicaid and other government benefits. These strategies can save thousands and sometimes millions of dollars of a family's savings. However, these strategies are very complicated and can cause more harm than good if not properly implemented. Therefore, don't give anything away until you have been advised to do so by a qualified long-term care attorney. Otherwise, Medicaid may impose enormous penalties that preclude you, your spouse, or a loved one from ever receiving benefits. There are three main tools we use for long-term care planning. They are powers of attorney, long-term care trusts, and Medicaid compliant annuities. We will now discuss each of these tools. Powers of attorney allow agents to make financial and healthcare decisions for patients when they no longer have capacity to make decisions for themselves. Families are powerless to conduct long-term care planning without them. However, powers of attorney for long-term care planning are very unique. They cannot be found on the internet and are offered by very few attorneys. Therefore, if you already have powers of attorney, it is very unlikely that they authorize the agent to conduct long-term care planning. The powers of attorney must specifically authorize the agent to create, trust, make gifts in excess of the federal gift tax exclusion amount, and change the names of beneficiaries on financial accounts and life insurance policies. If your powers of attorney do not provide these powers, you will need to get new powers of attorney. If it is unknown when the patient will need to apply for Medicaid or VA benefits, the first step in planning will be to create a long-term care trust. This is a very special type of trust that very few lawyers understand or know how to prepare. Assets that go into the trust will not be considered as resources for purposes of qualifying for Medicaid or VA benefits. However, there are waiting periods and other requirements that must be complied with to shelter assets in the trust. The sooner the trust is created, the more assets your family will be able to protect. When the time for moving into a nursing home becomes imminent, it is time to start converting countable assets into exempt assets. For example, a retirement account owned by either the patient or his or her spouse with $500,000 in normal investments will have to be spent on nursing home bills before the patient can qualify for Medicaid. However, by purchasing Medicaid compliant annuities in the IRA, the patient may immediately qualify for Medicaid while protecting $500,000 for the spouse's support or children's inheritances. However, purchasing Medicaid compliant annuities is extremely complicated and should only be done under the guidance of an experienced elder law attorney. One mistake can cost your family everything. We can provide your family with the legal advice it needs to protect assets with Medicaid compliant annuities. Thank you for watching this presentation on long-term care planning. During your free telephone consultation, we will answer your questions about what type of planning is best for your family. We will call you at the scheduled time. If you have not yet scheduled a free long-term care telephone consultation, please call 251-431-6014 now.